editorial of The Hindu, right? A very important I came across actually a very, very interesting and an important editorial, and I was like, this is something that needs to be discussed. Now, while looking at the newspaper or while reading the newspaper, most of the students really cannot understand the aspects which are important, right? Especially the editorials part. They automatically assume that they are going to be complicated and difficult, and they just leave with them. So it's not always a good idea. Some of the editorials are taken, exactly the way they are in the newspaper by the consortium. So if you don't really understand what the editorial is all about, then you're not really reading the newspaper properly. So if at all there is an article in the newspaper, whichever newspaper you're reading, which has a legal connotation to it, becomes important immediately, and you need to write it down, or at least write down the principles that are involved in that article. Right? So there's a solid chance that that article is there in your question paper, and you'd have an advantage, right? So the article that we are going to discuss today is the one that is based on the due process clause and the basic structure doctrine, right? So before we proceed, you should know that we have a comprehensive course that we have started for CLAT 2024. Now, this is called a comprehensive course because it not only covers or takes care of CLAT, but it also provides everything that the students need for non-CLAT exams. So right from the day of preparation till the day of your exam, we are standing by your side, telling you at every step, guiding you at every step, what all do you need, right? So this is the reason why it is called a comprehensive course. Preparation, revision, practice, everything is taken care of by this single course. Even the notes that you need to prepare from are provided to you by BYJU'S exam prep portal. That's how easy and convenient preparation becomes if you join a program. So if you wish to find more about it, you just need to download the app and enter your phone number, unlock a 3-day trial period, which is available for free, and you can judge it for yourself. Now let's go over to the article, due process clause or basic structure doctrine. Basic structure doctrine is something that most of the students already understand. What exactly is it? Basic structure doctrine was, mentioned for the first time in Golaknath case. Golaknath case was before Keshwanand Bharti, right? Golaknath case, the Supreme Court said that the power of amendment under Article 368 conferred to the Parliament of India is not absolute and unlimited. The Parliament can definitely, amend the Constitution of India, but they cannot touch the fundamental rights. Now, this became problematic. In what manner? Obviously, there were certain things that people did in the name of religion and in the name of their rights. Now, in order to, make a society which is free of religious and evil societal menaces, these practices had to be curbed, and the Parliament had incorporated or legislated various provisions and criminal legislation so that people would stop doing those acts. Now, those acts were mostly done in the name of religion. The problem is that whatever it is that Parliament is doing to develop the country, to make the country better, more socialistic, the resource distribution is more wide and not just concentrated. People are not exploiting the minorities in the name of their majority religion. All of that was being done by the Parliament since the day we got independent, right? But after Golaknath ruling, all that they had done became absolutely worthless. For example, let's talk about Sati Pratha. Sati Pratha, although abolished by British, let's say that Sati Pratha continued even when we were independent. British did not deem it important enough to interfere with, and they allowed people to continue with this horrible practice. Sati Pratha was done in the name of religion. So if after we became independent and the Parliament sought to remove this practice by creating a legislation, penalizing it, they couldn't have done it. Why? Because Sati Pratha or the legislation penalizing Sati Pratha would be considered a direct attack on right to religion provided under Article 25. Article 25 is a fundamental rights. राइट एंड देर आर सिमिलर एग्जाम्पल्स दैट यू कैन टेक. तो अगर पार्लियामेंट सती प्रथा को हटाना चाहता है तो वो नहीं हटा सकता. क्यों? क्योंकि सुप्रीम कोर्ट ने गोलकनाथ के जजमेंट में कहा कि आप जो भी करना चाहे कर सकते हैं कॉन्स्टिट्यूशन के साथ, बिल्कुल अमेंड करिए, लेकिन फंडामेंटल राइट्स को टच करने के बारे में सोचिएगा भी नहीं, वो पावर आपके पास नहीं है. अब बहुत सारे डेवलपमेंट के प्रोसेस में बहुत सारे राइट्स होते हैं जो वायलेट हो ही जाते हैं. जमींदारी ले लेते हैं फॉर एग्जांपल. जमींदारी एक बहुत ही खतरनाक प्रैक्टिस थी जिसने कंट्री को बिल्कुल हैंडीकैप्ड बना दिया था. सारी की सारी प्रॉपर्टी और जमीन एक पर्टिकुलर फैक्शन के पास कॉन्सेंट्रेट हो गई थी और बाकी मेजॉरिटी फैक्शन जो था वो भूखा मर रहा था. वो किसान जिसे स्ट्रगल करने की जरूरत नहीं थी क्योंकि उसके पास जमीन है, वो किसी एक बड़े आदमी ने हथियार रखी थी और इस आदमी को कुछ भी करने की कोई आजादी नहीं थी. जमींदारी को हटाना बहुत जरूरी था ताकि कंट्री को सोशलिस्टिक बनाया जा सके. वो लोग जो गांव के गांव अपने नाम करवा के बैठे हैं उनके हाथों से वो गांव छीनने जरूरी थे ताकि सबके पास जमीन रहे. इंडिया प्राइमरीली एक एग्रीकल्चर कंट्री थी. लोगों को सिर्फ और सिर्फ खेती करनी आती थी, किसानी करनी आती थी और इसके लिए उनके पास जमीन होना जरूरी था. जमीन तो है ही नहीं किसी के पास क्योंकि जमीन सिर्फ जमींदारों के पास है. तो क्या करें? जमींदारों से लो और गरीबों में बांटो, रॉबिनहुड वाला स्टाइल, राइट. अब अगर आपको ये करना है तो आपको एक पर्टिकुलर ग्रुप के राइट टू प्रॉपर्टी को वायलेट करना पड़ेगा. ये पूरी जो कहानी शुरू हुई थी बेसिक स्ट्रक्चर की, वो राइट टू प्रॉपर्टी से ही शुरू हुई थी. 1951 में पहले इलेक्शन के आते ही गवर्नमेंट ने जमींदारियों को अबॉलिश करना शुरू कर दिया, राइट टू प्रॉपर्टी को वायलेट करना शुरू कर दिया. 9th शेड्यूल आ गया, फर्स्ट अमेंडमेंट आ गया, बहुत सारी चीजें आई जिससे राइट टू प्रॉपर्टी बार बार राइट सॉरी I often forget. Yeah, so let me just repeat everything. What I'm saying is that, let's start from the beginning. This Sati Pratha example, I think it is clear. Let's talk about Zamindari. So, Zamindari was a horrible thing that existed back when India got independent. A very, very horrible thing. The entire property was amassed or concentrated with a certain faction. And there was a majority of faction which was struggling for basic needs, shelter, food, etc. Now, when India became independent, the first thing that the newly elected government did was to do away with this evil practice of zamindari. And in order to do that, they had to violate right to property, which back then was a fundamental right. Now became the uproar. How can you violate the right to property? It is a fundamental right and this and that. And there were several amendments, case laws and various case laws, petitions, etc. And the Supreme Court got confused what to do. And everything was done in the name of development, but in the name of development, there were fundamental rights that were getting violated. And that is where Golaknath judgment came. An 11 bench judgment which declared that you cannot even touch fundamental rights. So the abolition of zamindari becomes worthless. The abolition of sati pratha becomes worthless. If a man wants to marry 50-60 times, it also becomes worthless. But what I'm trying to say is that everything that is, even an evil thing, if it is done because you have a certain right, has to be allowed by the government because it is done in the name of fundamental rights. Right to property or property can be amassed or concentrated in the hands of certain people while others die of starvation. Why? Because they have right to property. Right, so that is where, problems started emerging. And immediately after Golaknath, the government or the parliament felt, what is this? We have done so much so that our country can become more socialistic, more secular. We can do away with these evil practices that have been going on for centuries. What do we do now? So they immediately came up with 24th Amendment to nullify Golaknath judgment. Now, this fight was going on since 1951. There was a particular amendment or there was a particular judgment which supported the parliament or didn't support the parliament. And to nullify that judgment, parliament came up with an amendment. Then the Supreme Court would come up with another judgment to nullify that amendment. And this practice was continuing. And the Supreme Court understood that we have to come up with a proper solution. Otherwise, this fight, this tussle will never end. And that is where Keshwanand Bharti comes up. a beautiful judgment, a 13-bench judgment, which changed the history of law in India. We have two eras, one pre-Keshwanand and one post-Keshwanand. And that is where Supreme Court came up with a basic structure doctrine, in which it allowed Parliament to do anything it wants with the constitution. You want to change the name of the constitution, change it to Whitehead Smurf, do it. If you want to change the font, the lines, the way the constitution is written, the design, everything, do whatever it is that you want. But think about it. Say, for example, there's a certain foundation, right? Now, on the foundation, if you are to build a structure, you can do whatever you want with that structure. You want to make it round, make it round. You want it to be a rectangular thing, make it rectangular. You want to use it for commercial space, use it. If you want to create residential plots in it, do it. Do whatever it is want with the building, but do not touch the foundation, because the foundation will actually help the building to stand. If you touch or disturb or violate the foundation, the building will come down. It will get demolished on its own. It won't be able to stand. That is why do not touch the foundation. The foundation is something that gives building its proper structure. And the foundation is something that gives you the actual power. So you can do whatever you want with the building, with the constitution, but do not touch the foundation of the constitution. And this foundation was named as the basic structure. So the parliamentary structure that we have is the basic structure. The fact that we are a democracy, we have a right to choose our own government, is a basic structure. The fact that we have equality as our fundamental right is also a basic structure. But of course, the fundamental rights can also be amended. So the spirit of equality cannot be disturbed. But people who are not equal, people who are being marginalized, who are being discriminated against, they can be given special rights so that they become equal somewhere or the other, somewhere down the line, or somewhere in the future, right? So this is what we call the basic structure, and the basic structure cannot be touched. And this was laid down in Keshwanand Bharti. Now, basic structure is not defined in the constitution anywhere. The Supreme Court also did not define it. But as we move forward, they determined what would be the basic structure, right? So it was a very well played move. Basic structure was also tried to be nullified in 42nd Amendment or through 42nd Amendment, but it was, again, 42nd Amendment was completely removed. So this article basically was on due process clause or basic structure. The thing is that, when you are reading an article, the opinion is not something that really matters, but the gist of that article matters. We have आशी 100% बिल्कुल आ सकता है. एक बार को 5 में नहीं आएगा, पर 3 में 100% आएगा, right? So we understand what basic structure is. Basic structure is important because we recently celebrated 70 or some years to the basic structure doctrine. Okay. Now we have due process clause. अब article में क्या लिखा है, what is written in the article, what the author is trying to say, is not something that you would be questioned upon, but you would be questioned upon the subject matter that the author chose to write upon, which is the due process. What exactly is the due process? Due process, before we get into due process, let's try and understand the principle. So, whenever there is, a right in question or a violation of a right, or any law that is seeking to violate a right or that has violated a right, due process is a kind of a doctrine which sees or which compares the violation or the law and the right. It is basically law versus right. So your right is generally violated by who? By the laws. There are laws coming every day almost, right? So some laws would be good, some laws would be bad. But the actual determination of whether a law is good or bad, whether it violates a right or not, is something that due process doctrine determines. So we have two aspects of this doctrine, substantive and procedural. It is also discussed, it is not discussed in the newspaper, but the editorial mentions it specifically. Due process has two aspects, substantive and procedural. What is the substantive aspect? The judicial examination of whether the fundamental elements of the legislation are consistent with the Constitution is the substantive due process. Whenever there is a whenever there is a law in question or an act of the government in question, and we are going to examine it from a point of view of violation, the first thing that the Supreme Court or any judicial apex authority does is to examine it from a constitutional point of view. So if at all there's a law in question, you see if the law is according to the spirit of the Constitution. Is it following the directive principle? Is it based on a directive principle? Is it in any way violating the fundamental rights? Is it following or based on the spirit of our Indian Constitution? If it is, then the law will be allowed. But if it is not, it is violating the Indian Constitution in any which way, whether it is violating a fundamental right or whether it goes outside the principle of DPSPs, the directive guidelines, or whether it goes against the entire, against what Constitution stands for, then that entire law will be declared void. Right, and this part of due process is called a substantive due process. When a law is examined on a constitutional aspect, whether it is following the Constitution or not. Okay, rather than fairness of the legal system, the court is more interested in the constitutionality. Every type of review, aside from those involving procedural, is therefore a type of substantive review, anticipates the substantive provisions of any legislation, and it sees that they are rational, following the Constitution and not arbitrary. So this is the principle that enables courts to defend particular fundamental rights against interference from the government. Like I said, very, very simple. Then we have the procedural aspect, envisions a reasonable process, meaning the aggrieved party should have an equal right to a hearing. So when it comes to the procedural due process, we see if the process is fair, just, and reasonable. Whenever there is an FIR launched, or whenever there is a violation, criminal or civil, okay, criminal or civil violation calls for a case. If there is a crime, there would be a case. If there is a civil violation, there would be a case. So whenever there is a case, whenever the matter is taken up by the courts, whenever a matter is taken up by the judiciary, the first thing that happens is that the procedure becomes active. So court has a certain process. You cannot just go to the court in front of the lordship and present them with your complaint and ask them to give you remedy. No, it doesn't happen that way. There's an entire process involved. You'd first have to, talk to a lawyer, institute a case law, then get it notarized, then seek a date, and then you would appear. Even when you appear, there would be certain documents that are required. You would have to bring witnesses, you would have to bring documents that support your arguments. If it is a criminal action, then there's another process, absolutely different process. The prosecution is required to establish guilt, the FIR copy, the evidence, the testimonies, people who have seen him committing the crime, his, if the character is important in any manner, what he has done in the past, etc. Everything is, is done in a certain manner, is done through a certain process. But whether that process is fair, just and reasonable is a question of fact. And that is what procedural due process calls for. So if there is a person in question, if there's an accusation on a person that he has committed a crime, then you cannot just assume that he has committed a crime. You would require the prosecution of the person who puts all those allegations to prove that he has committed a crime. And if he's able to somehow prove through evidences that yes, a crime has been committed and it is in fact committed by the accused, then the accused will not be punished straight away. He'll also be given an opportunity to defend himself. Do you agree with the charges? What do you have to say in your defense? Why did you commit the crime? Were you trying to defend yourself? Were you under intoxication? Were you manipulated by something? Did you commit a mistake? Everything will be clarified, but not just by hearing one party. Another party will also be heard at the same time. and then the judgment would come out. So this is what procedural due process is. When you are judging a law based on how fair the process is and how, reasonable it is when it comes to all the parties that are involved in that process. That is what procedural due process is. So if any of the procedural law fails to consider the rights of the parties, both the parties, then that procedural law is declared to be void, and that is what we call procedural due process. That's very random. Sometimes I wonder when I'm teaching, what is it that comes to your head? जब मैं पढ़ा रही होती हूँ तो आपके दिमाग में क्या आता है? आप मेरी बात सुन रहे होते हैं, फिर आप अपना पढ़ रहे होते हैं। मैम की क्लास बैकग्राउंड में चल रही है, मैं अपना कुछ कर लेती हूँ और फिर उसको करते करते प्रॉब्लम होती है और फिर बच्चे पूछते हैं मैम इसका मतलब बता दीजिए। सेशन से कोई लेना देना नहीं, सेशन से कोई लेना देना नहीं, ऐसा नहीं होता। सेशन पे ध्यान दीजिए, फोकस जरूरी है, ठीक है। मैं समझा देती हूँ सब्सटैंटिव एंड आई शैल एक्सप्लेन सब्सटैंटिव एंड प्रोसीजरल ड्यू प्रोसेस वंस अगेन इन हिंदी। ड्यू प्रोसेस का मतलब होता है एक लॉ को एग्जामिन करना कि वो लॉ सही है या नहीं। बेसिकली ये ड्यू प्रोसेस है, ठीक है। ड्यू प्रोसेस, लॉ प्रॉपरली प्रोसेस हो रहा है या नहीं, इसको ऐसे समझ सकते हैं। सब्सटैंटिव ड्यू प्रोसेस का मतलब है एक सब्सटैंटिव लॉ या फिर एक नॉर्मल लॉ, कोई भी लॉ। सब्सटैंटिव बेसिकली वो लॉ जो कि राइट्स एंड ऑब्लिगेशंस डिटरमाइन करता है, वो लॉ कॉन्स्टिट्यूशन को फॉलो करता है या नहीं, वो कॉन्स्टिट्यूशनल स्पिरिट के अकॉर्डिंग है कि नहीं, फंडामेंटल राइट्स को तो नहीं वायलेट कर रहा, डीपीएसपी को फॉलो कर रहा है, कॉन्स्टिट्यूशन की ओवरऑल स्पिरिट के अगेंस्ट तो नहीं जा रहा। अगर ऐसा होता है तो उस पूरे के पूरे लॉ को वॉइड डिक्लेयर कर दिया जाता है। इसको सब्सटैंटिव ड्यू प्रोसेस कहते हैं। दूसरा लॉ आता है प्रोसीजरल लॉ। अगर आपको अपने राइट्स को एनफोर्स करना है तो आप प्रोसीजरल लॉ को फॉलो करते हैं। राइट को किस तरह से एनफोर्स किया जाएगा, कोर्ट को क्या क्या करना होगा, आपको क्या क्या करना होगा, आपको कहाँ कहाँ जाना होगा, किस किस तरह के डॉक्यूमेंट्स चाहिए, कोर्ट आपसे क्या क्या डिमांड कर सकता है, कोर्ट में जाने के बाद आपके पास क्या क्या राइट्स होंगे, क्या आप अपने आप को प्रेजेंट कर सकते हैं, क्या आप अपनी बात को रख सकते हैं, क्या आप अपने मन के डॉक्यूमेंट्स ला सकते हैं, अगर आपके पास डॉक्यूमेंट नहीं है तो क्या आप सब्सटीट्यूट लेकर आ सकते हैं। ये सब कुछ प्रोसेस डिटरमाइन करता है। राइट वायलेशन होने के बाद आपको रेमेडी किस तरह से दी जाएगी, ये प्रोसीजरल लॉ डिटरमाइन करता है। अब उस प्रोसीजरल लॉ का भी फेयर होना जरूरी है। क्राइम हो गया, आदमी पे एलिगेशन लग गए, माय लॉर्ड इसने क्राइम किया, माय लॉर्ड यूं ही मान लेंगे चलो ठीक है तुमने क्राइम किया, जाओ जेल में? नहीं। प्रोसिक्यूशन को या वो इंसान जो एलिज कर रहा है कि माय लॉर्ड इसने क्राइम किया है, उसे प्रूव करना पड़ेगा। बस उसके कहने से जज उसकी बात नहीं मान लेंगे, उन्हें डॉक्यूमेंट से, विटनेसेस से, टेस्टिमनी से, बहुत सारे एविडेंसेस से प्रूव करनी पड़ेगी ये गिल्ट। और जब तक माय लॉर्ड 100% सेटिस्फाई नहीं हो जाते कि हाँ वाकई इसने क्राइम किया है, तब उनके दिमाग में कुछ आएगा। 100% सेटिस्फैक्शन के बाद भी वो ऐसा नहीं कि सजा सुना देंगे, वो उस आदमी से पूछेंगे हाँ भाई बताओ तुम्हें क्या कहना है अपनी सफाई में, क्यों किया तुमने क्राइम। हो सकता है वो अपने आप को बचा रहा हो सकता है उससे गलती हो गई हो सकता है उसने गलती से मैनिपुलेशन में या किसी के डर की वजह से क्राइम किया हो। तो जब तक कि दोनों पार्टीज को प्रॉपरली सुन नहीं लिया जाएगा, जब तक उनको अपना केस पूरी तरह से प्रेजेंट करने का मौका नहीं दिया जाएगा, तब तक जजमेंट नहीं आएगा। ये है एक फेयर प्रोसेस। तो प्रोसेस कितना फेयर है, प्रॉपरली पार्टीज को राइट्स मिल रहे हैं या नहीं, पार्टीज के ऊपर कोई अननेसेसरी अफ्लिक्शन तो नहीं है, अननेसेसरी बर्डन तो नहीं है, ये डॉक्यूमेंट लाओ, वो डॉक्यूमेंट लाओ, सब कुछ प्रूव करो, इसको बुलाओ, उसको बुलाओ, कहीं बहुत ज्यादा खर्चा तो नहीं आ रहा, अपने राइट को एनफोर्स करते करते आदमी बैंकरप्ट तो नहीं हो जा रहा। ये सब कुछ प्रोसेस ध्यान रखेगा। इन सब चीजों को प्रोसेस को कंसिडर करना पड़ेगा और तभी वो जाके प्रोसेस फेयर, जस्ट और रीजनेबल होगा। और इसको डिटरमाइन करने वाला जो डॉक्ट्रिन है वो है प्रोसीजरल ड्यू प्रोसेस। आई होप आई एम क्लियर नाउ एवरीवन। इंग्लिश एंड हिंदी, एनी प्रॉब्लम व्हाटसोएवर? Ashi, this class is not an everyday class. This happens, it is a weekly class. It happens once on Friday and once on Sunday. So on Friday, it is conducted on the portal BYJU'S Exam Prep. And on Sunday, it is conducted here on Sunday. Oh, sorry, on YouTube. Okay, good. अब प्रोसीजर बात आती है ड्यू प्रोसेस के साथ साथ there is another thing that we need to learn. We have understood this, but there's another thing that you need to learn. Due process is similar to another doctrine which is also called procedure established by law. You must have heard procedure established by law. Where have you heard it? Can anyone tell me? So like I'll answer your question, sweetheart. Don't worry if I said something. But you know, these questions which are random, it is better that you keep them towards the end, because you know how it is. I'm very focused and, you know, in the zone. So if you pop a random question, I come out of the zone, and that is not desirable. I get irritated immediately. So we can definitely do these questions, or I can clear your doubt, but either in the beginning or towards the end, right? I think that's fair. You'll get your questions answered and my zone will be uninterrupted, right? So yes, anyone? Where have you ever heard the procedure established by law? And if you have, where have you heard it? If you have read it, where have you read it? Anyone? No one? No one? No. Procedure established by law is something that Article 21 clearly incorporates. Right, Article 21 is nothing but 2 lines. Right to life and personal liberty cannot be taken away or violated except by the procedure established by law. This is where we see this phrase. So what is the difference between due process and procedure established by law? That is the only important facet of that entire editorial. Right, so whenever you read a difficult editorial, don't be shocked by the kind of language that is used. No. Consortium will test you based on what is written in the editorial and what might be there. So since we are talking about due process in that editorial, procedure established by law automatically becomes important, right? Because these are 2 doctrines which determine the fairness of a law. Okay. So what exactly is due process? I already told you. Due process is an American concept taken from Magna Carta to see or to examine whether a law is fair, just and reasonable. Whether it is depriving a person of his right and personal liberty, whether it is violating any right that is given in the Constitution. Right, so everything that a law shouldn't do and everything that a law should do is examined by the due process of law. Is the law following the due process? Is the law how it is supposed to be? Is it following the rights of the people? Is it giving rights to the people? Is it giving proper, significant rights to the people? If there's a process, then is the process fair, just and reasonable? All that is determined by a doctrine that we call the due process doctrine. Now, due process is not anywhere mentioned in the Constitution of India. We instead have the procedure established by law. So let's discuss a little bit of history. Sir B.N. Rao, the Constitution Assembly advisor, and Frankfurter J. from the United States of America Supreme Court expressed their concern about using the due process clause. Basically, Dr. B.N. Rao in the Constitutional Assembly, or Sir B.N. Rao, the advisor of the Constituent Assembly, said that instead of incorporating procedure established by law, we should actually incorporate due process of law. That is more wide, and it would suit our democracy in a proper manner. We are a democracy with certain rights and obligations to the people. We owe it to the people. The government is for the people, to the people, by the people, and all that. So if the law is not following the people, taking care of the people, what is the government doing? And that is the reason why due process of law should be part of Indian Constitution, not procedure established by law. The term involves fundamental prerequisite of providing an opportunity of the heard. It is based on the concept of natural justice. People should not be condemned without hearing them first. Everyone should be given an equal opportunity to represent themselves. Nobody can be condemned without an opportunity of being heard. All the principles of natural justice flow from the due process. Justice Krishna here equated the procedure established and procedural due process and mentioned that orderly process involves being heard and for the law to be just and fair. Okay, moving on. What is procedure established by law? everything that law says. In simple words, procedure established by law is a narrower doctrine which says that rights can be taken away. Fundamental liberty of life and dignity can also be violated, provided that it is violated using a procedure established by law. So if anything is done using a proper process, using a proper channel, then that thing cannot be questioned. Simple words में लॉ सही है या नहीं, ड्यू प्रोसेस उसे एग्जामिन करता है राइट्स के बेसिस पे कि भाई लॉ राइट्स को वायलेट तो नहीं कर रहा, लॉ लोगों को तो परेशान नहीं कर रहा, लॉ फेयर है, रीजनेबल है, जस्ट है, ये है ड्यू प्रोसेस. लेकिन लॉ बना कैसे है, लॉ को फॉलो किया गया है या नहीं, कौन से चैनल से आया है, सही अथॉरिटी ने बनाया है, सही अथॉरिटी ने पास किया है, सही से प्रोसेस को फॉलो किया है. मतलब लॉ ने जो भी किया है या जिसने भी जो भी किया है, लॉ को फॉलो करते हुए किया है. एक आदमी को अरेस्ट कर लिया, एक नॉन बेलेबल, सॉरी दैट इज हिंदी अगेन, I shall repeat it in English. Whether or not law is followed, it doesn't matter how the law is. But what the law is, how the law is something that due process determines. But the character of a law is something that procedure established by law is not concerned with. Whether a law is arbitrary or fair or unreasonable or unfair, whatever it is, does not matter. What matters is that the procedural that this unfair, arbitrary, unreasonable law has laid down is followed or not. If it is followed, then whatever is done using that procedure is not void and it is completely valid and cannot be questioned. And that is the reason why even the dignity, fundamental aspect of life, personal liberty and dignity and life is also or can also be violated if the procedure established by law is followed. Now, procedural established by law was given a very, very narrow interpretation from two cases. A.K. Gopalan, you can read them if you want as homework, and ADM Jabalpur. Since we did not have due process, we only had procedure established by law. These two cases with the Supreme Court came up with an extremely narrow and a very, very bad interpretation of procedure established by law. This was a time when the emergency was going on, when, the government did not really care about the democracy. All it cared about was the power. The emergency was imposed on arbitrary terms. People were suffering because of it, and the government was not listening at all. Okay, opposition was not respected in a manner that it should be, especially in a democratic setup. Nothing was done that was legal and democratic, but it was done using the procedure established by law. So if you are arresting a person without giving him any right to be heard, or without giving him any right to say anything, and you arrest him without a warrant, without an explanation, and you arrest him only because he dares speak something against the government. And there's a law that is telling the authority that you arrest anyone who speaks against the government, and you don't need any warrant, any permission. Just put them in jail. Do not give them any right to bail. Do not give them any lawyer. Just let them be inside the jail. Let them rot in the jail because they have dared to speak against the government. And there's a law which is saying it. The police officer follows the law, puts that poor man inside the jail because he's trying to tell people that this law is unfair. We are in a democratic setup. We have rights. But he's speaking against the government. He's inside the jail without any recourse to that from that custody whatsoever. But this man cannot challenge the law. This man cannot, avail any remedy. This man has no right. Why? Because his right is violated through a law. All that is done, all this unfair treatment that he has suffered through is done because there's a law laying all of it. And since there's a law giving all of it, it is absolutely valid. So whatever procedure law has laid down, doesn't matter how the procedure is, if the procedure is properly followed, the act, no matter how bad or stupid it is, will be valid. And this was the interpretation in short that was given in A.K. Gopalan and ADM Jabalpur. But Menka Gandhi changed the game. In Menka Gandhi versus Union of India, the Supreme Court finally interpreted procedure established by law in a manner that it should have been done in the first place. Procedure established by law was similar or interpreted in a similar manner as due process. In this case, Menka Gandhi case, obviously, the Supreme Court said that if a right is violated, and the right is violated using a procedure that the law has given, the violation is fair. But the process that has taken away that right needs to be fair, just, and reasonable. And if that process is unfair, unjust, and unreasonable, then that process is also void, and the law that it lays down is also void. यहाँ पे सुप्रीम कोर्ट ने खेल दिया और प्रोसीजर स्टैब्लिश बाय लॉ को ड्यू प्रोसेस के लाइंस पर ही इंटरप्रेट कर दिया कि चलो ठीक है, अगर किसी के राइट को वायलेट किया गया है और वो वायलेशन ऐसे प्रोसेस को फॉलो करके किया गया है जो लॉ ने ले डाउन किया है, तो वो वायलेशन वैलिड है, उस वायलेशन को क्वेश्चन नहीं किया जा सकता. लेकिन जिस प्रोसेस से आपने राइट वायलेट किया है उसका फेयर, जस्ट और रीजनेबल होना कंपलसरी है. अगर वो प्रोसेस अनफेयर है, अनजस्ट है और अनरीजनेबल है, तो वो प्रोसेस जिस तरह का वायलेशन कर रहा है वो भी अनफेयर है. वो प्रोसेस अनफेयर है, जो लॉ उस प्रोसेस को ले डाउन कर रहा है वो भी अनफेयर है. सिमिलर इंटरप्रिटेशन हो गया, लेकिन ये आया मेनका गांधी के केस में था. इससे पहले वी वर बीइंग इंटरप्रेटेड और वी वर बीइंग गवर्न्ड बाय दिस नैरो प्रोविजन ऑफ प्रोसीजर एस्टैब्लिश्ड बाय लॉ. बट देन द गोल्डन ट्रायंगल रूल, the connection between article 14, 19 and 21 was interpreted in a beautiful manner. Now comes another concept which is called golden triangle. This is your homework. What exactly is the golden triangle in the Constitution of India? This is your homework. Make sure that you do this homework. Do not forget to do this homework. Okay, very important. So that's it for today, guys. I hope you have understood these two doctrines. Very important doctrines. They play a significant role in the interpretation of rights and liabilities of both citizen and the state. So make sure that you watch this session again if you haven't understood. Tulika, we shall deal with your doubt in the class later on. Right now I have another class, so I would have to leave. Everyone, take care. Please like the session if you've enjoyed it. This is a weekly session that happens every Friday on BYJU'S exam prep portal. And it also happens on YouTube on some Sundays. But if we get good enough response, we can make it a weekly session on YouTube also. But then it would depend upon how many students are attending. Portal pay, it is a success, but right now here, there's not enough turnout, right? So thank you guys. Take care. Bye-bye. Take care.